Good afternoon, everybody, and welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide an update on the latest developments at the court and the opportunity to ask questions. In the trial of Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi, the trial panel on 26 November granted in part a request by the Thaçi defense and admitted into evidence 5 witness statements made by one witness prior to their witness testimony in court. The panel permitted the admission into evidence of the statements for the sole purpose of verifying the consistency of the witness statements, which may have an impact on the weight and credibility the witness testimony will be given in the final deliberations. On 1st December, the trial panel granted in part a request by the Krasniqi defense to admit into evidence 144 items that are not linked to any witness testimony. The trial panel admitted into evidence 112 of these items and rejected 32 because the items in question are either not disputed, not relevant to the charges, or the defense has failed to establish how the respective item is relevant to the charges. The panel has exercised its discretion to admit some of the proposed exhibits where it could identify relevant information in an otherwise irrelevant item. The panel reminded the parties to clearly identify in their final submissions what material they are relying upon in their case and what probative value and relevance they attach to each piece of evidence. Also on 1st December, the trial panel granted in part a request by the Thaçi defense to admit into evidence 166 items not linked to a witness testimony. The panel admitted 149 of these items and rejected 17, finding they are either not relevant to the crimes charged in this case, or the defense failed to explain their relevance to any fact or circumstance in this case. On 2nd December, the defense of Hashim Thaçi and Jakub Krasniqi formally closed their cases, indicating that they do not intend to call any further witnesses or present additional evidence. On 3rd of December, the trial panel issued a decision on agreed facts between the parties. Based on the rules of procedure and evidence, the panel may consider such facts as being proved, unless it is of the opinion that a more complete presentation of evidence of the alleged facts is necessary. The panel noted, however, that not all parties agreed on all the facts in question and declined those that were not unanimously agreed upon by the parties. As such, it took note of 29 facts and considered them as proved and declined 20. The trial panel has set the 19th January 26 as the deadline for the prosecution and the defense to submit their final trial briefs and for victims' counsel to submit a statement on the impact of the alleged crimes on the 155 victims participating in this case. The closing statements are scheduled to take place from 9th to 13th February 26, with the 16th and 18th February as reserve days in case the closing statements take longer than anticipated. Following the closing statements, the trial panel will close the case and enter into deliberations in order to reach a judgment. The judgment should be pronounced within 90 days of the closing of the case. Where the circumstances require additional time, a further extension of 60 days is possible. In the case of Hashim Thaçi, Izni Kilay, Bashkim Smakay, Fadil Fazliu, and Hayreddin Kuchi related to allegations of the illegal influencing of witnesses, the single trial judge on 2nd December granted a request by the prosecution to request further information on a report by an external forensic company concerning a search for a specific statement amongst the digital records extracted from printers and computers allegedly used by Hashim Thachi at the Specialist Chambers detention facility. The defense had no objections to the request. On 3rd December, the single trial judge ordered the continued detention of Mr. Thachi, Mr. Smakai, and Mr. Fazliou. While he did not find or consider a risk of flight for any of the accused, the single trial judge saw a real risk that the accused may obstruct the progress of proceedings and found that at this stage of the proceedings, only the measures in place at the Specialist Chambers detention facility could substantially reduce the possibility of witnesses being influenced. During the trial preparation conference that took place on 28 November, the single trial judge issued an oral order directing the prosecution to file its motions concerning evidence not linked to a witness statement until 17 December 2025. That was all from me. If there are any questions, I'll be happy to respond.